Okay, hello everybody. I'm John Haig. I am the co-director of the Mosava Rahmani Center for Business and Government, and I'm very happy today. We have a topic that is close to my interests and heart, and it is really, the title today is Big Tech and Digital Platforms as a Threat to Traditional Antitrust Thinking and Regulation. And given that I spent about 15 years working in the telecommunications sector for a large company called AT&T that went through some massive restructurings in light of various antitrust actions. I just find this an incredibly interesting and important topic. We have with us today to really lead the discussion, Michal Halperin. And I don't know how many of you know Michal, but she's a legal expert in the fields of competition, antitrust laws and regulation. And she is an MRCDG senior fellow. And we're happy that she's here for this year, and she'll be here for another year after this. And, you know, she was also, between 2016 and 2021, she was the Director General of the Israeli Competition Authority, which is a quite significant position. And the authority really transformed to become, you know, a key player in almost every economic reform in Israel. So antitrust considerations lead you into many dimensions of the economy and competition more generally. She was head initially of the competition and antitrust group of MITRE Law prior to being at the Competition Authority. She's been chief legal advisor at the Israeli Competition Authority, where she headed roughly 25 legal experts. From 2000 to 2001, she was a special legal advisor at Mintz Levin here in Boston, a law firm here in Boston. And she was an intern in the Supreme Court of Israel out of law school, and a lawyer at Ernst Ben Nathan Talid, I'm going to mispronounce it, Toledano, advocate, becoming a partner there after 5 years. So, and she's a graduate of the law faculty of the Hebrew University in Jerusalem. And she has helped us bring into the discussion Frederic Jani, who is chairman of the OECD Competition Committee since 1994. And this semester, he is teaching, this year, I think, is teaching at NYU Law School on issues of antitrust. So with that, I'll let Michal give a more complete discussion and introduction of Frederic Jani, but I would like to thank Frederic for joining us today. I think we're fortunate to have him here.
So thank you, John, so much for your opening and for the warm words and the introduction. It's very nice of you. I want to start by saying that I really feel that we're privileged today to host Professor Frederic Jani. And I will start by introducing him, but Professor Jani, I have to apologize in advance for not highlighting every achievement you had, because I do want to leave some time for you to speak today. But I will say that Professor Jani is professor of economy, and he's the chairman of the OECD Competition Committee since 1994. So it means almost 30 years. He's also a professor at the ESSEC Paris Business School. He was previously director of the Office of Fair Trading in the United Kingdom for 7 years, before it transformed to be what we know today as the CMA. He was a judge on the French Supreme Court from 2004 to 2012. I believe, Professor Jani, correct me if I'm wrong, that you were the only economist ever to serve in the French Supreme Court. Pretty amazing, because at least in my country, lawyers believe that they hold all the wisdom in the world. And he was a vice chair of the French Competition Authority for 9 years and president of the WTO Working Group on Trade and Competition from 1997 to 2004. He has a PhD in economics, University of Paris, and a master's in economics from Harvard University. He was a global professor of antitrust in NYU School of Law and was visiting professor in many places: College of London Law School, Haifa University in Israel, University of Cape Town, Keio University in Japan, Northwestern University, and now he teaches in NYU on antitrust and international law and on globalization. And I will add on a personal note that I know Professor Genie since I joined the Israeli Competition Authority for the first time in 2002. But I am especially grateful for him for the support that he gave me when I entered my position as head of the Israeli Competition Authority in 2016, which was valuable and unreplaceable. So it's really a pleasure to have you as a guest today. So before I start, I want to mention that we will start with a kind of a conversation between me and Professor Genie, mainly Professor Genie talking, but you can all use the Q&A button and put in some questions, and we will collect the question, and I promise to leave the last part of our seminar today for the public to join in and to ask questions. So do put in your question in the Q&A, and I'll try to manage all of them and give everyone's the answer. So with this, Professor Genie, can we start?
Absolutely, we can start. There's only just one correction that I want to make. This is the fact that I got a PhD from Harvard.
Okay, so correction certainly in place, and sorry about that.
No, that's fine. I also got a master's degree, so it's fine.
Okay, so let me hit you with the first question, Professor Genie. In antitrust, you know, we have a lot of disputes, but there is one fact that no one argues about, and that is that in the last 2 years, the issue of digital platforms and big tech dominated the discussion of our field totally. So I want you first maybe to explain, why does this topic attract so much conversation? What are the unique characteristics of this area, and what challenges do they bring to the antitrust field? And in addition, after a few years of very intensive discussion on the topic, I want you to reflect whether you think that competition agencies are now equipped to deal with with these competition issues of digital economy. Do they have the relevant personnel? Do they have a relevant and sufficient economic understanding? Where do you think they're standing on this?
Okay, thank you very much, Michal, and to have me. I mean, it's very nice to be back at Harvard after many years, and to talk about competition and the digital economy, which is, as you pointed out, one of the crucial topics today. One of the reasons I think why one talks so much about it is because competition authorities are in fact facing what I would describe as 3 challenges when it comes to the digital economy. The first one is to understand competition between platforms and ecosystems. And the reason this is a challenge is that competition between platforms is very different from competition between what we call pipeline firms, which are the traditional firms. Or understanding of competition is that traditionally there are different firms which are present on the same relevant market. They're duplicating what each other do, and they're competing mostly on price to get maximum number of consumers. And this is the process through which the allocation of resources gets organized and gets efficient. Now, this is what is called the Stiglerian static price competition framework, because it is price competition, because it is static, and it represents to a large extent one of the teaching of the Chicago School. Now, platforms do not compete on price. At least they don't compete on price on the sides on which they offer their services for zero. I'm not saying that it's not a counterpart, but it's not a price as we know it usually. So that means that they compete differently, and they compete through offering to the users differentiated combinations of innovative services, which are attractive and which are the reason why one chooses a platform rather than another. So this is a very different nature of competition. It's much closer to what one could describe as the dynamic Schumpeterian competition on innovation. And the problem is that competition law is less well equipped to deal with such a competition than to deal with the more static Stiglerian approach. So what the first sub-challenge is to better understand the relationship between competition and innovation to assess competition among platforms. Second, platforms are not attached to a particular market the way a steel mill is attached to the steel market or the way a car manufacturer is attached to the automobile market. And the reason is that the technology that they use, that is the algorithm that they use, and which allows them to facilitate certain types of interaction between users, that same algorithm allows for different type of interactive services. So they can move with the algorithm from one type of service to another type of service. Not to all of them, but to a variety of them. If you take Amazon, for example, its algorithm helped it develop book sales, but equally, it helped it develop sales of many other things, and not only books, as it did originally. So platforms can very easily move the combination of services that they offer, thanks to their algorithm, and they can easily move across markets. Well, for the best example of this that we know is the case of Instagram, for example, which was a photo app, but nobody was expecting they would become a social media. And when Facebook bought it, at the time, Facebook thought, and everybody else thought, including the CMA, not the TMA, but the UFT, which was dealing with this merger in Europe, that a photo app is not directly competing with a social media. A photo app may be part of the offering of social media, but it's a much more technical and limited thing. Well, it turned out that Instagram became a social media in itself. And had we understood this at the time, probably the merger would have been blocked, but it was not because nobody understood that at the time. So the notion of relevant market, which is absolutely central to the analysis of competition, the traditional analysis, is not particularly relevant in the case of ecosystems. As a matter of fact, it can lead to massive errors. Likewise, the analysis of potential competition is very different from what it is in the non-digital world, for the reasons which I mentioned. Potential competitors could be other platforms which produce something completely different, a completely different set of services, but could, thanks to their algorithm, invade the particular market or offer the same kind of services. Now, we have developed in competition, or in the static approach to competition law, a concept of potential competition, which is very narrow, where a potential competitor is a firm which is already on the market, but could grow as a significant competitor. Here in the digital world, potential competitors can be completely different firms doing other things. Okay, so we have to allow for this. The third dimension is that platforms use complementers. A complementer would be an app developer to increase and diversify the set of services that they offer to the users. So to attract those complementers, but also to select them, they establish rules of governance with respect to the app. So those rules establish which app will be allowed on the platform under which condition. Now, the platform or the ecosystem does that to attract the most attractive combination of services for potential users. So there is clearly an interaction between the relationship between the core platform of an ecosystem and its complementer on the one side, and the attractiveness of the ecosystem and its ability to compete with other ecosystems on the other. So competition within the ecosystem is linked to competition between ecosystems. And that dimension has not yet been explored by competition authorities, who focus to a large extent on competition within the platforms. The fourth and next to last element is the fact that artificial intelligence developed in such a way that when algorithms are trained on large set of data, they lead to better quality results than when they are trained on more limited sets of data. Now, this means that larger platforms with more users will tend to offer better services than smaller players, and this will create a tension between size, concentration, and performance. Okay, bigger size tends to lead to better performance, but of course it leads also possibly to market power, and also a conflict between the desire to protect privacy and the desire to promote economic efficiency, because the larger the sets of data that a algorithm can use, the better will be the performance of the. Now, finally, and I will finish with this, not all, but most non-digital markets, like the cement industry or the automobile industry, which I was referring to, in most of those markets, competitors share the same business model. A steel mill buys coal, buys various inputs, transform them into steel and sell the steel beam. Okay, maybe differentiate according to quality or to size, but we understand what the business model is. So in the traditional world, it's relatively easy to define competition on the merits by looking at the way business is done and to decide when a practice is at odds with competition on the merits and to impose the remedies to ensure that competition on the merits take place. But this is not so in the digital world, where Google and Apple, for example, are two ecosystems with completely different business models. Google is based on ads, and therefore it offers a lot of services for free to a very large number of users. Apple has very exclusive and very expensive terminals that it sells to people who are most interested in quality. So it has a more restrictive policy in terms of apps on its platform. Okay, so one of the consequences of this is that a remedy that would be useful for Apple, if there was an anti-competitive practice of Apple, may not be useful for Google because Google has a different business model and vice versa. So there's no unique solution to the competition problem between platforms, and remedies have to be adjusted to each business model. Now, all this is to say that there's a rich policy literature on competition between platform and ecosystem, but this business policy literature has not been examined really by competition authorities or by competition specialists, and therefore there's still a lot that we need to learn. The second challenge is to adapt the traditional competition law tool to the specificities of the digital sector. It's largely a consequence of what I said earlier. Because we have a different approach, some of the instruments that we use are useless when you talk about the digital sector. Just one example, it is rational for platform to cross-subsidize some users in order to better benefit from network effects. Okay. So it means that it is rational for them to sell at zero price on one phase in order to have a maximum of advertisers and charge the advertisers for their service. Now, it means that the model that we have of predatory pricing, which is anything below cost, should be prohibited, doesn't work in such an environment. Now, I'm not going to go into those because we don't have time, but there are plenty of instruments that have to be adapted. And the third challenge is to resist the political pressure to intervene at all costs. There are many reasons for this pressure. One is the desire to maintain, of course, competition as a source of innovation, but there are other pressures coming from wanting to monitor the risk, the democratic risk associated with social media, which can use your information without you knowing what they do with it, or which can influence you unduly. And there are still other reasons, such as the feeling that some of the practices that big tech platforms use are unfair, and unfair to the complementers, unfair to the app developers. So competition authority should be mindful that the competition law instrument should be used for what it is good at, and not necessarily the protection of competitors. And second, should also be adapted to the digital sector.
So it sounds to me, if I understand correctly, is that your general understanding or impression is that there is still a way to go until competition agencies will be able to tackle the issues of digital platforms properly. Do I understand you correctly?
Yes, you did. At OECD, for example, we've had so far, I think, about 40 roundtables on various aspects of the digital economy and competition. And I still think that there's more to be done to really get a precise understanding of how competition is different, what is similar, but what is different, and then to adapt our instrument to this. And the problem, well, I'll come back to this, but one of the problems is that this is a work that takes time, and there's this urge to intervene even before we've done this. This is one part of the problem.
Yes, so I'll move forward to another question that I think you slightly touched in your first answer, but I would like to hear more specifically and in more details that when we are discussing digital platforms, I think one of the immediate dilemmas is whether we should prefer ex ante regulation or whether we should go for the traditional ex post enforcement that was done in the last few decades on traditional market, and whether to allow a more flexible regime where every industry may be regulated differently. I think this is more the approach that the UK is now discussing whether to adopt, or maybe we should insist on more certain and general ex ante rules, more like the European approach as it evolved into the Digital Market Act that will be enacted apparently by the end of 2022. So I wanted to ask, what do you think is the best way forward? Do we need to keep our flexibility, or do we need to be transparent and do strict rules, and whether we should stay with the ex post traditional enforcement?
Okay, I think that the ex post traditional enforcement in a quasi-judicial context or in a judicial context, it depends on the country, is very well suited for relatively static environments. In other words, markets that don't change, like the cement market that I was referring to, where a case can be thoroughly analyzed and lead to a jurisprudence which will be both relevant in scope, because it will apply to all the cement manufacturers, and it will apply also across time, because the business model of the industry doesn't change. Now, the problem is, I think, that in the digital world, the effectiveness of this quasi-judicial process is more debatable, A, when you have an environment that changes rapidly, and B, when you have a diversity of business model, because it means two things. First of all, time is of the essence, because there are important changes that are taking place all the time. And second, solutions to the problem raised by one firm may not be the same as the solution to problem raised by its competitors. So for this reason, and yet we do have spectacular example. The most recent one, of course, is the Intel case, which is close to what we're talking about, even if it's not a digital case. Okay, in the Intel case, where Intel was accused of abusing its dominant position and through an anti-competitive conditional loyalty rebate, the commission took a decision. Then 10 years later, the courts annulled the decision of the commission. And we are only halfway, because there are now both the commission has appealed the most recent judgment. So it's going to take 15 years before this is resolved. Now, in an industry where you have conditional rebates on the usual basis, this is already very long. When you're in a digital world, 15 years is not relevant, because the world will have changed considerably. So my personal feeling is that there is scope for regulation as a complement to competition law. But there is a huge caveat to keep in mind. Regulation is just like competition law enforcement. It requires an understanding of the way in which competition functions in the digital sector. Because just as I said, you cannot enforce very well if you don't understand. You may come up with regulations which are completely anti-competitive or anti-economic if you don't understand this. So we need to have a good understanding for regulation as well as for enforcement. So this leads to two observations. One of them is that it is fundamentally unsound to base a regulation on past cases which were adjudicated when the understanding of the competition issues in the digital sector was not very advanced, to say the least. And it would be unsound to derive from the remedies adopted in such cases general rules which are applicable to all platforms because they have a diversity of business models. And unfortunately, this is essentially what the DMA does. Okay, so it has an advantage as the first regulation, but the basis of the DMA is very shaky. It comes up with a long list of general obligations for firms considered to be gatekeepers, and those remedies are derived from past or even current cases, such as Google Shopping or Google Android or Apple Music streaming, which is a current case not yet decided, or even the Microsoft case. Now, to understand why this is dangerous, let me point to 5 characteristics of those cases. First, in those cases, each ecosystem is considered to be a relevant market. So they are assumed not to compete with each other. Google Android, for example, starts with the assumption that Google is not competing with Apple as an ecosystem, and that therefore Google has a dominant position over Android because Android doesn't have any competitor. Now, this is great to be able to impose some remedies, but one can question whether this is realistic to say that ecosystems do not compete with each other. Second, in many of those cases, the users of the digital service are assumed to have behavioral biases, and in particular status quo bias, and the anti-competitive nature of the practices of the platforms crucially depend on the existence of such biases. For example, in the Microsoft case, where Microsoft was tying its media player to its browser, people could have downloaded another media player, but there was this assumption that people had a status quo bias, so they wouldn't do it. So therefore, it would block competition for the competitors. So the third characteristic is that, at least in Europe, this is more of a European case, foreclosure, but Europe has been way ahead in the enforcement. Foreclosure or market exclusion of competitors can be established by the competition authority, that is the Commission, with a very, very low standard of proof. And in particular, the Commission doesn't have to establish the fact that there was an actual exclusion or an actual foreclosure. It's enough to say that there could have been an exclusion or Now, this leads to a funny result. You may have heard that recently the European Commission sent a statement of objection to Apple about its payment system. This was based on the origin of this was a complaint by Spotify. And one of the charges in the statement of objection is the fact that forcing firms like Spotify to go to the payment system of Apple is an exclusionary practice because it makes Spotify more expensive than it would be otherwise. Now, this is an interesting case. By everybody's acknowledgement, Spotify is probably the most successful music streaming firm that exists. Now, Apple is accused of having foreclosed the market to Spotify, which is a bit strange, to be honest. But the reason is that the Commission doesn't have to show that there's been actual foreclosure. The fourth characteristic is that in all those cases, the remedies are largely designed to increase the choice of the users. Okay, so Microsoft was supposed to have a version of Windows without the media player so that people could choose their media player, etc. The problem is that if people have a statu quo bias, they don't care about having choices. And the effect has been that no one has wanted the version of Windows without the media player. So the remedies are not in sync with the assumption of the behavioral bias, which is the basis on which the enforcement is done. And finally, none of those cases have been confirmed yet by the EU courts. Now, to use those cases to build a regulation for the future, I find is a bit dangerous. I would have preferred if there had been a real thinking about how does competition work in the digital sector, and therefore what are the principles that we can use to regulate. So this is not to say that regulation is not useful. It is to say that one has to be very careful. Now, there are different types of regulation, and in the UK, you made a reference there, the CMA has come up with a different proposal, which is not to impose a priori 16 obligation as the DMA does, but to have, for each case, a market study, which will analyze what are the competition issues, and which will allow the DMU, the Digital Market Unit, to impose code of conduct on the firms. Now, this is a much more bespoke approach. It is not that I have a priori prohibition. I will see what needs to be prohibited after I do a precise analysis of each case. So it's much more respectful of the business models that we're going to discover, and it's much more flexible in terms of, and much closer to a competition analysis to decide what should be regulated. So I think that more flexible and more bespoke regulation are more sensible.
But wouldn't you think that there is a good argument to that this flexibility costs with a lot of uncertainty, and that the businesses innovate and they invest a lot in research and in innovation, and at the end of the day comes regulation that could not have been anticipated, and then they limit the way that the companies can act. So there's a lot to say for certainty.
To be honest, you're absolutely right. Regulation can inhibit innovation. Okay? That's true. And lack of regulation can also inhibit regulation. Now, what we're saying here is that what we have to have is intelligent regulation, a regulation which will allow competition through innovation. Okay, so that's what I'm not sure the DMA does, but I've got more certainty that the DMU, with the adequate personnel, and you referred originally to the fact that to understand those business models and therefore understand how competition works, one needs to have people who understand the technology as well as competition. Lawyers and economists are great, but they may not be quite sufficient to get to the bottom of this issue. So this is why, for example, the CMA is proposing to hire a very large number, as a matter of fact, more than the EU Commission, number of specialists to help the regulator understand what the issues are and have an exchange with the firms to see what regulation could be useful and what regulation would be not useful and would have the effect that you are fearing of freezing innovation.
Yes. So I want to ask you another question, Professor Genie. One of the present challenges is that there's quite a lot of blur. What is competition? What is a competition concern? And what is outside of the jurisdiction of competition agencies? So, for example, in the US, there's a blur. The blur is very evident when you hear the discussion on the growing concentration in major industries like the pharma industry or the food industry. And this discussion is not used by the antitrust and competition agencies that usually look at very specific markets and define them in a narrow way. Or the discussion on the growing economic power of big tech. as opposed to market power that traditionally is used by competition agencies. So I wanted to ask you, do you think agencies are confused? Do you think that they are reaching beyond their boundaries, or do you think that maybe we should really expand their boundaries beyond the traditional antitrust and competition analysis as we looked at it decades ago?
Your question is interesting because it's somewhere it assumes that there is a natural boundary of competition law. And it asks whether we've gone too far or whether we're at risk to go too far and to enlarge unreasonably or unwisely the scope of competition law. The problem is that most of the countries in the world have competition laws that include public interest considerations. So therefore, they go beyond consumer welfare. If I take the next door neighbor to the US, the Canadian competition law, for example, announces in its first article that it has the goals of expanding opportunities for Canadian participation in world markets, okay, and to ensure that small and medium-sized enterprises have an equitable opportunity to participate in the Canadian economy. Now, these clearly, those two things, they're different from maximizing consumer welfare. The European law, one of its goals is to promote the achievement of the single market, nothing to do with consumer welfare. As a matter of fact, some legal expert thinks that it should not have anything to do with consumer welfare because that's not in the EU treaty. The law in South Africa promotes the employment and advance of social and economic welfare of South Africans and a greater spread of ownership, in particular, to increase the ownership stakes of historically disadvantaged persons. The competition law of China promotes the socialist economy of the country. So we have, the discussion on whether the consumer welfare is the absolute definition and should be the boundary of competition law, this is a US-centric debate. Because in Europe, for example, in most of the world, nobody asked that question because there have always been several goals of competition law, and consumer welfare protection has not been the only goal. It's been one of the goals of the competition law, but to be mixed with other goals which are public policy. So what it means that in those countries, competition law should be enforced in such a way that it is compatible or supportive of these other public interest goals. So if I look at the debate, I think there are two issues. One of them is the neo-Brandeisian in the US are asking the question of whether the consumer welfare should be interpreted differently or should be eliminated to have a wider vision. And there's a terrible battle over what Mr. Sherman in particular and Congress at the time meant. And I'm pretty sure that they did not have consumer welfare in mind. That seems to be historical evidence, historically obvious. But when we look at the debate on the digital sector in the competition world, in a more, I wouldn't say that the proposals for regulation or for modification tend to include public interest goals in the scope of competition laws. When you look at the regulations, for example, they tend all to limit the ability of big tech firms, so there's a question of how does one define them, to self-preference their product or to bundle their services or to discriminate or to impose price parity clauses. All those questions are technical questions on how the markets and the competition function in the digital world. So it seems to me that they are part of the traditional scope of competition law. Similarly, when you look at the obligations, a lot of them impose interoperability to allow app developers to have an easier access to the platforms. So I don't think that the technical debate on digital is much focused on including, I know that there's a political discussion, but this is not the same as the discussion which takes place within the competition community on the issue of the digital. My concern is more related to another confusion, that the confusion between the goal of competition and public interest. The confusion I have in mind relates to whether the practices which we want to regulate should be regulated because they hurt consumers or because competitors complain about them and find them unfair. So there may be, in fact, a slight confusion between competition mechanism and unfair competition. But this is not the same as what your question assumed, that we were introducing public interest consideration in, and if you look at the German amendment of the competition law, the EU DMA, the Klobuchar bill, I don't believe that one can say that they introduce public interest consideration into competition law.
So do you, I think this argument becomes most prominent when we deal with the big merger cases. So how much can agencies block mergers with for other reasons than the traditional reasons that we've seen in the past?
Well, I wonder whether this is what they're trying to do. I think that the difficulty there is to understand the counterfactual. What would happen if the merger did not take place? And the crucial question is whether the target would survive, develop, and become an active competitor, or whether it would wither away. And there, I think that we have to be mindful of not being too simplistic. In order to succeed in the digital world, you need at least three things. You need to have an innovative service, something that's better than what other people do. But you need also to be able to create scale of network effects. So to acquire a lot of users in order to attract a lot of, a lot of advertisers, in order to be able to monetize your invention. So you need a business model and you need money. If I take Spotify, it costs Spotify about €1 billion to develop its users to the point where the media and the music company took Spotify seriously. So we're talking about big investment. So when we're thinking about potential competition, we have to have in mind, is the service innovative? Could it develop into something else? Would the target have the money or the access to the financing to develop its network? And four, would it have a business model that would be sustainable? It's only under those conditions that one can say, well, absorbing a firm that would have all those four characteristics could be an impairment of competition. I think that competition authorities have been too much focused on, is this a service that could compete with an existing service of the acquirer, and not enough about the other conditions which are necessary. And the cost of this may be that if you block mergers that of firms that would not have developed naturally because they lacked either the financial ability to develop their network or the business model, you also risk blocking innovation. A lot of people innovate new services, but after that, they want to sell their firm because they know that they won't be able to develop them by themselves. And we need those innovations. So there's a trade-off there. We don't want to let through anti-competitive mergers, but on the other hand, we don't want to block mergers which are the source of innovation and would not have developed as competitors. So for this, we need to better understand what allows a target, often a new firm, a startup, to develop on the digital market.
John, you want to?
So I'll exercise a little bit of my prerogative. I see we've got a question or two in the chat, but so I have a slightly different orientation question, and two of them really. The first is, when you think about a lot of these big tech companies, they're truly global in nature, right? When you look at Apple, they get less than 50% of their revenues from the United States. When you look at Alphabet, Google, they get less than half of their revenues from the United States. And they operate on a global basis, and information flows around the world are just dramatically increasing, even though other forms of trade seem to have flattened and may retrench a little bit in light of all the things going on. And so you have a situation where you have the rules, if you will, set at the nation state level, but you have firms operating on a global basis. And the question really is is it possible to have a global governance structure of any sort where you rationalize how these companies are handled in different parts of the world? So, the example I'd give is like GDPR, right? And there's a first mover advantage to kind of putting a regulation like that out. But once you do that, then California looks at it and they write a similar piece of legislation. And then Brad Smith from Microsoft comes in and says, wait a minute, I don't want to have 180 different versions of GDPR around the world that I have to meet to. There are high fixed costs for me of developing the software and the structures to support it. Can we get one set of regulations that are similar enough that I may like all of GDPR, I may not, but I'm happy to live with it, but let's try to standardize. I don't know if that's realistic to expect that to happen. And then in the same vein, how do you resist kind of the first mover inclination, the advantage of being first mover? And then, as you said, the second question is really around the question of what are the right institutions to deal with these issues within a country. So if you look at the United States, the Sherman Act was so vague, and basically it evolved to the courts to do what has historically been potentially a regulatory function. And regulatory agencies. But if you go back to something you said earlier, that kind of a regulation is unsound, kind of given a set of markets that are rapidly evolving, and you have a lot of innovation, the past may not be a good, and courts are inherently slow. So as you pointed out, like a decision can take 10 years to get resolved, and by that time the world is just vastly different. So what are the right types of institutions within government structures to try to manage these complications and these big tech kind of interactions?
I think it's a very interesting and important question at this point, precisely because we're entering the regulation, right, the regulatory period. The first thing I would say is that we should distinguish the convergence on substance and the convergence on the type of regulation. What is the most important to me, I think, is convergence on substance. And you were taking the example of GDPR and California. I'm not sure that California adopted GDPR because GDPR was first, but I think that there were convergence of ideas. I'm not saying anything about whether it was a good convergence or not, but I think that this is how things happen. Now, convergence will come fairly rapidly, as it did in the competition law enforcement before the occurrence of the advent of the digital sector, if competition authorities are exposed, do the steps that I was talking about. In other words, realize that their instruments may not be the proper instrument, that competition may be a bit different, that therefore they have to adapt. As I said, the OECD, as for example, which is a place for coordination and cooperation, we've held more than 40 roundtables on different aspects of this, precisely to try to bring people together. We have a book which is the summary of all those 40 roundtables, and now we are considering the possibility of coming up with high-level principles that would be, I don't know whether we will get there, but we at least are trying to translate all this work into high-level principles on which everybody could agree. Okay. So the process of convergence does take place, not only at OECD, I guess, I think more intensely at OECD than elsewhere, but in many international instances, because I think that competition authorities understand that if they each have the same cases as the other competition authorities next door against the same firms, eventually they're spending all their resources where they could save them if they had more unity among them, and if they could find a way to either to have the same regulation or even possibly to have an enforcement which would be aligned and more centralized than it is. So I think that the desire of the professionals to have a unified regulation is a good one. And I think that it is shared by competition authorities as well. Are we there yet? Not really, because I think that we still have work to do. And as I said, I think personally that joining up the literature on business policy and how competition works in the digital world with the competition principle and the competition policy literature is the best way to move forward. Now, when it comes, so it seems to me that we should not overemphasize the advantages of being the first one out. Just because you're the first one out doesn't mean that people want to copy you. And I think, for example, that Ms. Klobuchar's proposal is not copied for the DMA. Okay, so it's a different one. She sees those practices as being illegal if they are unfair, whereas the EU doesn't talk about unfairness. It just prohibits some of the same practices, such as self-preferencing. So just because there is a regulation out there doesn't mean that everybody's going to copy it. I think people are going to think to that. This is crucially important because if there is no agreement, in fact, what wins is a regulation which is the most constraining, because business firms want to have security, as you said, right. And they just go by the stricter standard, whether they like it or not, by saying at least like this, even in the most strict, which is not a satisfactory solution intellectually. But I think that the competition community, at least, is very aware of this. And you know that there's a high-level group between the US and the EU to discuss those issues, particularly relevant to the digital sector. So I think that the institution may be bilateral cooperation, but it may be also multilateral cooperation in the context of an organization like OECD, and it's incumbent on those institutions to promote cooperation and convergence, which we do.
Yeah, if I may, I will add to that during the conversation I had with European regulators when working on my paper, my impression was that they're not in any race to be the first. They would much prefer to have a unite approach together with the Americans. I think they're skeptical whether they can get it, but I think they would, if it was possible, they would much prefer to have a two-headed regulation that would be more uniform across the two sides of the Atlantic. That's
possible if one starts from what is the competition problem or how are the competition problems in the digital sector. It's much more difficult when one has a regulation which is based on past decision of one jurisdiction, because maybe the same cases would have been decided differently in other jurisdictions, and therefore it's much more difficult to arrive at convergence. So that's why I think that thinking about what the issues are is crucially important before coming up with regulations or having flexible and bespoke regulations.
Yeah. Since we're heading towards the end of the hour, I want to read the questions that was put on the Q&A. I think it's a pretty basic one, but I do want you to be able to react to it. And that is, there has been no discussion of specific harm yet. If time heals all wounds, what is a harm in need of healing by regulatory intervention? And when will time in the innovation take care of things? I might raise the case of Yahoo. So I wanted, for you to be able to answer
Yeah.
this.
The fear or the suspicion is that time is not going to heal the harm. Time is going to make them more entrenched and more difficult to eliminate. And this fear is based on the idea that a lot of the benefits that firms can get through their strategy, including the anti-competitive strategy, are more scale economies, more scope economies, and more network economies, which are going to entrench their, and more data, which are going to entrench their activity. So that's why there is the idea, for example, that if you self-preference your services compared to the service of complementers on your platform, you're going to create a movement which is going to be self-sustaining and is going to exclude from the market once and for all the complementers, and there is not going to be over time something which is going to counteract this. So this is because there's a cumulative dimension to competition in the sector because of the number of users and because of the entrenchment in the number of services. There is this feeling that there is a need to act and we cannot wait for the market to adjust. I mean, it's easier to wait for the market to adjust if we're talking about automobiles or cement or any of the markets that we were talking about before. But in the case when you have created the condition for your domination, which leads to a better performance than the others because you've got more data in particular, it means that there is never going to be a possibility for the competitors to catch up with you. And this is what the fear is.
Yes, so I want, if that's all right with you, to wrap up with the subject that you know that is close most to my heart, and that is the international collaboration and the need to get to some kind of convergence globally and how we treat the big tech and the digital platforms. So you started to refer to the subject when you had this discussion with John and the race to be the first to regulate that. What I wanted to ask you more specifically is, what are the areas in the antitrust where you think it is most hopeful that we will be able to create or promote a convergence to some degree?
Okay, I think that besides the general understanding of competition, there's another dimension which I mentioned, which is what is the relationship between competition and innovation. Now, this has been a vexing issue for competition authorities for a long, long time, because economists have not been able to come up with something which is really usable and very, very strong. But let me take an example to show that. Okay. We are in favor, I mean, there's an a priori in favor of interoperability between the very large platforms and the complementers so that the complementers can have an easy access to those. And that sounds like a good idea, the ability for potential competitors on one or the other service to access and therefore the users. The question is the following. If you are going to have interoperability, it means that you are going to have a format for the data to be interoperable with the whoever wants this interoperability. Now, it means that the complementer is going to have to take into consideration the format in order to make sure that his innovation is interoperable with you. And the question is whether the existence of such a format is going to limit the innovation that would have happened if there was no format for interoperability. Now, I don't have the answer to that question. I studied a little bit this question in the particular case of the connected car, because the format in which the information from the car is transmitted to the insurance company to the repairman or the possible repair services to Google and others who might want to have access to the car, makes a big difference in the way in which they can provide services. Now, it seems to me that this kind of question, before we rush to say, okay, everybody, all the major platforms must be interoperable, period. We want to have a little bit of thinking about, okay, is there really an issue with innovation, or if there is not? If there is an issue with innovation, what does that mean? Should there be automatically several formats of interoperability, which is a cost for everybody, but might allow more freedom for the complementers to innovate? Okay. So since the digital sector is mostly about innovation, I think that thinking about the relationship between competition and innovation is crucially important. So I think that this is probably the area where we could test the remedies that we have in mind, which are remedies inherited from a static approach to competition, but to see whether they have only advantages or whether they also have drawbacks in a more digital framework.
Interesting. Yeah, so I see that the time passed very quickly, and I don't want to drag it to take too much of your time and the participants' time. So I want to wrap it up and tell you again, thank you very much for making the time and coming to talk to us. And thank you very much for this interesting talk. And thank you, Victoria, for recording and arranging everything. Thank you, John, for hosting Frederic in Mustafa Rahmani Center. So thank you all. Thank you for joining in. And Professor Jenny, again, thank you so much for your
thank you to you and to John for having me.
Thank you so much, Frederic. Thank you.
Okay.